years of practice, it's a joy to speak in front of your preceptor who has nurtured and developed you. It's a great moment. I beseech your best wishes and blessings before I proceed to talk. I owe my professional life to Shri Natarajan, here before me. We also recognize the presence of Mr. B. Kumar, Senior Advocate, who is now my current teacher on money laundering laws. I've started to learn the basics of this law gradually and slowly, and in spite of his cross schedules, he's willing to spend adequate time irrespective of the time schedule, whether it's 9:30 in the night or 12 o'clock in the night, a 1 hour discussion on the phone call, he's ready to spend with me and try to, because we wanted to ensure that what we speak is technically not wrong. Whether it is technically correct is a debatable question in the court, but technically not wrong at least. So, I'm thankful to each one of you. I will only develop from where Mr. Ranganathan left. I think the orientation looks to be the same in our thought process. I'll just gradually improve from where he left. There are many definitions to black money. Many. Illicit money, founded, illegal, antisocial, contrary to conscience, etc., etc., etc. But the global language of black money as it is understood is creation, origin, creation, movement, and use of illicit funds. That's the technical, possibly reasonably accurate expression to the terminology of black money in a global space. Its creation, then its movement, and its use across continents in different destinations. This looks to be the end use or the use of this black money. It achieves two purposes. It goes to legitimate use, and it also goes to illegitimate use. We call the legitimate use as global growth, and the illegitimate use as global disaster. Both are happening. This money has two sides, a promoting side and a destructive side. When it comes to numbers, every author is very, very, very cautious, saying that we are not very sure. That's the caveat they first put. Because assessment, the yardstick, and the accuracy looks to be extremely in variance. But two reports we can take it as an authentic source. One is the OECD report, and the other is the IMF report. If we take these two, in 2009, OECD benchmarks it at 11.8 trillion in 2009, and IMF at 18 trillion. And the accretion could be anywhere between 1.5 trillion to 3 trillion in a year. So, if the conservative estimate in 2015 is say 22, 25 trillion or 36 trillion, it really doesn't matter. You must understand how many zeros we need to add to the first number. 1 trillion is 1,000 billion. And 1 billion is 6,000 crores. So if it is 25 trillion, it is 25,000 crores into 6,000 crores. The best of computers may struggle to deposit the last few zeros to see whether it's within its screen. This is the quantum of money that is involved in this philosophy called black money deal. Fine. This kind of a money, you can't carry it on your head or put it in your pocket. You need to move from one destination to the other. Now, how does it actually happen? There are globally two tools which enable movement of money from one place to the other. One is called the tax havens. That's the first tool. And the second tool is an auxiliary tool to tax havens, banking secrecy laws of the respective havens in the countries. These are the two solid walls which block you from knowing who the actual beneficial owner of the money is. Now, what do you mean by a tax haven? A tax haven is considered to be first an asylum jurisdiction or a low tax jurisdiction. That's the proximate definition of a tax haven. What do you mean by a zero tax jurisdiction? You need to park a lakh of rupees in your Indian bank account, earned income, then it suffers 33-34% of income tax. You park that 1 lakh rupees in a haven, and if it is a zero tax jurisdiction, you straight away save 33,000 rupees on the haven. So a tax haven enables you first to ensure your money is kept at a zero cost. There are three different types of tax havens, which I'll deal in a minute's time, but essentially this is the definition. 2, because it is a low tax jurisdiction, it is the source for funding money, giving you cheaper money to the world. Money is available at a cheaper price because it is tax free. And 2, it has possibly no exchange of information agreements, and therefore there is no compulsion to diverge. And 4, it is this place where amalgamations, mergers, acquisitions, and transfers takes. It forms the hub for these transactions to take place. So you have a zero tax, an enabling vehicle to keep shuffling and multiplying that money. And whenever somebody puts a accusing finger against you to say, please divulge information, you will say, I have no business to show all this information because I don't have an exchange agreement with you. This is how a tax haven is formed. The tax haven actually functionally works in 3 different models. They are just havens where you use the money to go as a conduit, as a first source supply for a zero tax. They can't do anything beyond that, whether it is Cayman Island or British Virginia or Liechtenstein or etc. Each continent has its own havens as a controlling interest. Each continent has its own. It's all dispersed very nicely across the globe. So they are the first source where you deposit to achieve zero tax. That's all. They can't manage, as the numbers are too small, they don't have a big economy, they don't have a big development or prosperity, therefore they don't do any economic activity there. It just goes there to, as a step down to make funds cheaper. This is one type of tax haven. The second type of tax havens are fund managers. Switzerland is one example, where you ensure you achieve a credibility to such a standard that world is willing to deposit there, and you will manage the funds. Because money has to move, as you were saying, money has to go either for a protective purpose or see, it's not that money goes only for a protective purpose. It also goes for a destructive purpose. You need to fund, you need to win elections in a particular state or in a particular country, you have to throw money. Where do you get it from? So the money has to flow there. So it is also for use for destructive purposes. So they operate as fund managers, secure a percentage for the services rendered, and they run their economy. So they're slightly better off than a Cayman Island. That's the second type of havens which work. And the third type of havens which operate are actually, they are not only fund managers, they are actually doing entrepreneurial work. There's one in the Middle East and one in the Far East which has achieved excellent progress as an economy, not on their own funds. By simply holding the money, simply managing the money, and exploiting the money also for its own growth. So these are the 3 types of tax havens you have. You possibly use them as vehicles to operate. An auxiliary to this is the banking secrecy. What is that which is ensured with these tax havens, which you are not ensured with any other country? Why don't you do it with a country which is a legitimate economy which progresses? You have a tax exchange agreement, and when you force, there will be a social compulsion, there will be a social pressure to divulge information. Which social pressure these types of tax havens do not undergo in their respective countries. There is no pressure to diverge. For example, the fund managing tax havens, they have a law which does not declare tax evasion as a crime. Tax evasion is not a crime in their jurisdiction. So, if a tax evaded fund is kept there, it is a legitimate fund in that economy. So, what do you do with that economy? What sort of a disclosure can you extract it from that economy? So, these are the three hubs, the three models in which it worked, supported by an extremely opaque and strong bank secrecy laws. Now, what do you mean by actually bank secrecy laws? This is going to be the bone of contention when we actually get into dispute, when we start doing all these leaked data are now government is collecting information, we are all fighting cases in different taxation jurisdictions because like an extradition method, that's what government is saying. Merely because you have a leaked data and you write to the government, that government cannot furnish that information that easily. There's a process. Like an extradition, you are given an opportunity to defend whether this data belongs to you. You have an appellate process to fight. And then if you are able to show either this data does not belong to you or the data that is sought is not foreseeably relevant for the investigation that is sought to be made, then that government has every right to deny disclosure to the government which has sought information. This is exactly the place in which the litigation today is positioned globally. Three taxing one goes via the High Court route, one goes via the adjudicatory route, one goes by the appellate tribunal. Three different jurisdictions which government is now soliciting information. This is exactly the position. So it's not that you can just write one letter and then get back the information and start pursuing a matter. It doesn't happen that way. So what do you mean by this bank secrecy there? This is exactly the confusion which government also has. They are skeptical, therefore, because the arrangement works in four models, global, broadly speaking. Like an Indian traditional conservative man, whether it is black money or white money, he will try to deposit only in his name because he doesn't trust anybody else. So he will open an account and put the black money in his name. That's the global philosophy also. There are people who still retain money only in their names. That's one model. But the second model is the much prevalent model across the globe. The banking institutions have their own supporting structures, trusts, foundation, etc., etc., etc. So if somebody says my money has to be kept, then they give you the support service. And the combinations, the multiplicity of the combinations happens depending upon the complexity of the involvement of the partners in the money. If 5 partners from 5 continents emerge into a place to join hands, then the complexity will multiply 15 times. Because from a legitimate source, you have to completely consider this was a big process, which is what this whitewashing process is happening. This is supported by, in these tax havens, invariably by their own supporting structures. Now the third option is, the person who wants to deposit is given the option to choose his own binomies. That's one option. And the fourth option is the most critical option, which is now going to be the headache for any government to fight with. The people who have been chosen as binomies, you can't find 1.5 million people in the world. You can find only few in various continents. These people manage their own funds and they put these respected individuals as their people. So this cross reference of, this is all under utter confusion, in complete mess, for the simple reason, 3 decades, starting from United Nations resolution, you keep tracking the website. So much has been insisted on the KYC norms, and none of the banks have ever followed any of the KYC norms in any part of the group. It's not possible. You can't follow a KYC norm and then have an illegitimate legitimized fund. Both can't coexist. So, what happens? All these, there may be more than 4 also. I'm just giving you the 4 principal models, and it multiplies in different ways. All this is now capped or sealed and what you call it under the banking secrecy laws. You can't go and touch a country and say, please give me the data. It will say, I have my own secrecy, I can't reveal it to you. So, the transition that is now taking place is in three parts. Prior to 2008, no information you could get it around. It's lost. Now this act is trying to now unwrap. That's why it says previous year. Whenever I find that will be the previous year. We will come to that little later. So 2008 era is one. Then 2008, then 2011. There are two periods. Some countries have entered into agreements saying that they entered into agreement in 2011 but giving retrospective effect to 2008. And the third era is going to be the era of automatic exchange from 2017. These are the three eras in which these transactions will be bundled. A 2017 transaction, you can't fight it on the grounds of bank secrecy. You have an automatic exchange. On writing a letter, the government is obligated to give you the information. Now, US has got a separate agreement in which India is also a signatory. Any US resident outside US, that it's an obligation of that fund or the bank or the government to disclose his details to US. They have signed such agreements. So that's one model. It's all moving forward. But for the past, you have these two models: no exchange agreement era and an exchange of information agreement era. And we are all fighting cases in different jurisdictions before courts and tribunals on this piece of 2008 and 2009. What is it? Is it foreseeably relevant information? Is it a necessary information? Do these data really belong to this person to whom you are accusing? All this is all in that foundational stages. Right. Now, we understand tax haven, we understand bank secrecy. Now, the white paper of the government classifies black money into three categories. 2012 white paper says crime component, the corruption component, and the tax evasion component. So, as Ranga rightly put it, the first two components are illegitimate components. Crime and corruption go together. And the tax evasion is one component. What do you mean by crime? Essentially two. They are sesame twins: terror funding and drug trafficking. That's the basic crime component. And one breeds the other. See, terror, what do you mean by terror money? See, it's all black money as a hot chase started only because of terror money. After 9/11, US went into the matter and it found out terror money is flowing into the US economy. And it pumped it out of its economy from 2001 to 2008. One of the reasons for subprime crisis is also that. So how do you organize this money? All money came from Middle East. It got washed off in a particular country and it was then sent into US. This was tracked down. It was clearly tracked down and it was flushed out. So terror money multiplies many folds because it is always put into drugs. Terror money is always invested in drugs and it's a quick return. So this is the crime component. Then the corruption component is kickbacks, round tripping, bribes, etc., at the political level and the bureaucracy level. And the third is the tax component. And you must understand, all the money is fungible, money has no color. All the three use the machinery of tax havens and the banking secrecy laws. So money gets mixed, commingled at all these institutional levels. It's not that you have a separate bank for terror and a separate bank for crime and a separate bank for tax evasion law. So these are the three forms which culminate, and the movement happens in these structures through the tax haven and banking secrecy law. Now let's talk it from the Indian perspective now. How does it happen in India? I'll give you one global model and then you will understand, as I said, crime and component very difficult to identify. And this black money law again is now going to leave them off, completely let them off the hook. And I'm going to cite you a judgment of the Bombay High Court which supports such a view in a minute's time. So this structure, I'll just give you one simple example, then you will understand how money travels and how money gets deposited. Suppose there is a US company which owns the patent of a particular product. It creates a subsidiary in Ireland where the tax rate is 12%. It gives an exclusive or non-exclusive use of that patent to that company in Ireland. Ireland a contractor in Singapore to replicate the product. The Singapore entity sells the product in India at $100. So you take a product in India at $100 from Singapore. Singapore retains $10 for the job work cost and $5 as its profit. $15 it secures. It transfers $85 to Ireland. Ireland pays $10 as a royalty to the US entity for holding the patent. So, US economy taxes the $10 at say at 35%. Ireland taxes $70 at 12%. And Singapore taxes $15 at whatever rate it wants. Simple. This subsidiary in Ireland is nothing but an extended arm of the US entity. If this money has to be in US at 85, it has to suffer 33% tax. So you create an entity in Ireland, you pay only 12% tax and keep that $70. This was the investigation US did a few years back. They found out the leading entities, maybe Facebook, Global, Apple, etc., etc., etc. Globally, they took the global balance sheet and they're starting to see they paid an income tax of just 3% of their turnover. All of us will be paying more income tax on what you earn. Whereas these entities have simply paid 3 to 4% on the global turnover. So this was the shock for US. Now it found out money. That is why even today we are all talking transfer pricing is an outdated law. It's going to be substituted with BEPS. US Congress is opposing BEPS. It's not going to come. Because BEPS is again value creation and money income, earning in the same territory. Value creation and money income is happening outside US now. So they don't want BEPS, they want money back. So this is the confusion, strong opposition by the Congress for implementation of BEPS. So Europe wants it. So this is the transaction sequence and how you suddenly save close to 20% tax on $80. Now same thing happens in India. There are two broad business models in money flows. You must understand here, nothing is illegitimate in one model. One step is illegitimate in the other model. Rest of the steps are legitimate. Very interesting to see how. Now let's take the first model of 4 steps. There is an excess invoicing and money flows out of India. That's how it is pumped. See, misinvoicing is a method. Misinvoicing doesn't generate, it only generates extra money. Then it has to be structured. The follow-up action has multiple combinations. Misinvoicing, so money flows out. So there is this money, otherwise earnable in India and taxable in India, goes out of the country. So this income doesn't suffer tax in India. It has gone out. Now it's coming back as an FDI investment. And what does your treaty say? For that matter, common sense, you never tax a capital because it's inflationary. You must only tax an income generated out of a transaction. You can't tax a capital. So the capital comes back. Through a DTA route, we normally bring our funds either through the Mauritius route or through the Singapore route. These are the 2 hubs through which we bring the money because we have DTA advantages. What are the DTA advantages? So the second step is money flows in. That money is not taxed, not taxable. Now the third step, you put the money in India and you multiply the wealth and the value of the share increases, which is the Vodafone case. The value of the share multiplies. But the share is held by a company either in Mauritius or in Singapore. And what does your DTA say? Any sale of these shares, there won't be a capital gains tax in Mauritius or in Singapore. So the first leg goes out untaxed. The second leg comes into India, cannot be taxed. The third leg, there is a value accretion happening in India, but the accretion adds to its value to a share outside India, and you transfer the share either in Mauritius or in Singapore, no capital gains tax. So every time you sell, you enjoy a 20% capital gains tax or 30% capital gains, as the case may be. To that extent, you save and the value of that money goes up. And it is recycled back as fresh FDI investment into the country as the first. So, please understand, the three steps is not illegal. You are all protected by DTA. You are all governed by trade agreements and double taxation avoidance agreement, therefore not legitimate. Now the confusion for the government, which is also what we are fighting for. Now, the money which comes as an FDI, is it the money which originally went out of India, or you took it from the fund managers of the tax haven as an entrepreneurial risk and then brought it to India? That's the question. Suppose an Indian entity contests that in the absence of any evidence, this FDI investment is what I have taken it from this source, and then where I may be a beneficial owner as an account holder, I bring the money into country and invest it. Please see the three cycles. The investment into India, Bombay High Court says it is capital in nature, not liable to tax. So no tax, no violation. The sale of the shares as a capital asset in Mauritius or in Singapore, no tax. The revisiting of the extra fund into India as an additional FDI, again no tax. So what is the offence? That's the question which the government may have to confront when the litigation matures to that level of intensity. So this is as far as the structure is concerned. No problem. Now the problem in India vis-a-vis US is this is the difference. In US, you don't have transactional black money on a daily basis. See, they hunted 8 years and they washed out crime money. Post the subprime crisis, now they are watching out on the tax evasion money and they want to plug it. And it's a country which will achieve it. Very simple. If they lower the rates of tax, which is a very, very difficult proposition in US. Suppose US says, I will tax all the transaction at 15%. What happens to entities like Ireland? It cannot happen overnight in US. It's a very difficult proposition. That's what people say. But if it happens. So it is something to do with such a structural change. It's a question of high tax base and therefore keep the money elsewhere. They don't have any other problem in keeping the money within US. Whereas that's not the situation in the domestic perspective. Domestic perspective in India is completely unique, extremely unique. Where do black money get generated in India? One, stock markets. You'll be baffled if you understand how it operates. 10 fellows gather, they spot out a share which is just 9 rupees. They find out the funders who can then want to wash off black into white. In 9 months, a 9 rupee share will go up to 900 rupees. Washing takes place, transaction gets completed, and from 900 rupees it will come down to 9 paise in next 2 months. You can. It's worse than muscle power. It's worse than muscle power. It's being so controlled. So stock is one area. Real estate, gold, and above that, liquor. Liquor is a sure shot money for any governments because it's controlled by the government. So it's the best spinner for any, except for 3 governments in India. Every government, liquor is under their control. So liquor. Like this, you have betting and gambling. It's such a traded commodity in India. You have about 7-8 pieces with you. Now, the underlying truth is this: what is the common base? Whether it is gold or liquor or share market or etc., etc., etc. What is the common base? Common base is a mass public which consumes it. Somebody does the washing somewhere at the cost of this gullible public. Because these fellows who improve it from 9 rupees to 900 rupees, they keep pumping the money. Their small funds also simultaneously. Gold price keeps going and you madly go and invest on gold thinking it will go up. You will never know when from 34,000 will come to 24,000. You have no control over it. So it's a betting. So it's so nicely designed. In all these areas, it is wherever there is a mass consumption or a public is involved, they become the gullible investors or consumers at the cost of this magic conversion of black money into gold. This is exactly what is happening in India. Now, this is and all this because of political connections, bureaucratic, etc., etc., etc. All these conversions takes place. Now, legitimized. How is government? What is see? government has to face it when it implements this law. It has to face this truth. Whether it is an 80 HLC exemption, which was one era what Mr. Rangasar was saying, or the GDR route, or the P notes route, please understand, these are all legitimate instruments conceived by Government of India for you to trade. They are not illegitimate instruments. They are legitimate instruments. What is the legitimacy? Government gives legitimacy to the instrument with an assurance that the investor's name will be concealed. Identity of the investor in the P note is not traceable. At least in GDR it is possible, but in P note it is impossible. The structure is so complex that even individuals can simply contribute something and be part of the whole scheme. So it is government did two things, magic things to ensure black money flow is systematic into the country's economy. It assured withholding taxes on shares. It took it away from the investor and said the companies will now deduct the dividend distribution tax. Investor is concealed, completely concealed. And it said the second thing, P notes, GDR, etc., investor is concealed. Now this law says, if you see the Amendment to Income Tax Act, explanation 4 and 5, read with section 3, 4, 5 of the black money law, I can simply issue a notice to the company and say, please show me the beneficial owner. The law says, don't show the beneficial owner for investor. The income tax officer can say, please show me the beneficial owner in the hands of the investee. And if the investee fails to show the beneficial owner, it becomes an undisclosed income or asset in his hands. You legitimize a transaction at one end, and you put the spokes to the other end by bringing this law that onus is on you to prove who the beneficial owner is going to be, or show me the beneficial owner. This is going to be a huge area of conflict as it progresses. So, in nutshell, before I go to the legislation in the next 15 minutes, 10:30.
Yeah, for some discussion we can have some time, 10 minutes.
Now, so this is the broad conspectus of how this black money law philosophy operates. In fact, like Ramayana, Bhagavatam, you can do 7-day, 10-day course on it. Each one has so much of detail. Now let's come to the legislation. That's important to all of us. They brought out two enactments. One enactment is already in place, what is called the money laundering law. It is there in 2003 itself. Now we have the Black Money Act, which is 2015. See, money laundering law, if you see between 2001 and 2008, 90 countries under the compulsion of OECD legislated money laundering law. After the 9/11 attack, after the terror crime was found to be the basis for black money funding. So money laundering essentially came up to nullify terror funding, technically terror funding. Of course, the definitions keep changing over a period of time. So you will see all the money laundering laws across the world happening between 2001 and 2009. This is now an economic legislation, the tax component. It's all completely driven by US. Otherwise, we will not be talking, this would not have taken the center stage. The leaked data of Germany in 2009 and the leaked data of French government in 2011 gave the impetus to US to drive this aspect globally. And today, you may not know your account holders, but definitely US has a complete idea of who are all holding what sort of account. It has so much it's an economy which drives by surveillance. With just 3 lakh people, 3.5 lakh people operating it, they have complete control over what is happening in a transaction. This is what they have achieved through their efficiency. We should give it to them. Now, this Act says, the Black Money Law Act says the following. Our concern is this. Let's come to the disclosure part first, because that is expiring in the next 4 days. It is no surprise it achieved 500 crores is one statistics. Now, President says it is 2,000 crores. Yesterday I saw it as 500. How it jumped to 1,500? Never mind. Even 2,000 is simply nothing, because the assumption we have is India records close to 500 billion is the black money of Indian contribution to the 20 trillion or 15 trillion, whatever trillion it is. So 500 billion and 500 crores is simply a mismatch. nothing. Why? Why? That's the question we should answer. The answer is very simple. See, I do not know whether it is a draftsman's mistake or a legislative design. If you see the voluntary disclosure scheme in 1997 of the Income Tax Act, it said two things. Anybody who discloses under the scheme, confidentiality is maintained. You are assured of confidentiality. That's the first assurance. And the second assurance, it says, we will grant you immunity from income tax, wealth tax, company and FEMA for prosecution. This black money law, chapter 6, which deals with 59 to 71, which is the declarant disclosure clause. It says in 59 you have to declare, and 60 is a charging provision specifically for this declaration. Otherwise the charging is under section 3. So it says every declared undisclosed income or asset will be charged to tax at 30% and 30% penalty. So it is not that the moment you declare, your offence gets erased. No, your offence is acknowledged that you are an offender. But we will give you immunity from penalty and we will give you immunity from prosecution. Of what? The draftsman who borrowed it from the VDA scheme, the same language, put the same language here also. Income tax, wealth tax, FEMA, Company Act and added Customs Act also. Overlooking the fact, VDS was part of the Finance Act. It was never a separate enactment. So the payment was in the character of income tax under the Income Tax Act. Therefore, an immunity under the Income Tax Act was good enough for them not to launch prosecution. Whereas Black Money Act is an independent parliamentary legislation. It's nothing to do with Income Tax Act. In fact, few provisions of the Income Tax Act is borrowed, and Section 4 very clearly says what is taxed under the Black Money Act will not be taxed under the Income Tax Act. There's a mutual exclusivity to it. So, when you say that this is a separate enactment, 67 ought to have said, we will not grant you immunity also from Black Money Act. It's not there in Section 67. Now, what are the consequences? If you don't grant an immunity in Black Money Act, first of all, Black money law is an independent legislation. It calls you an offender and you can be prosecuted under that law. Independently. 7 years, 10 years, depending upon the type of crime. So, it is an offence prosecutable under the law. The second jump is, Section 51 of the Black Money Act says, any willful attempt to evade taxes, interest or penalty will be a money laundering offence under Section 88 of the Act. So it becomes a money laundering scheduled offence under the Act. So that's a second offence you make. So if you don't immunize somebody from this Black Money Act, the consequences are, you go and file a declaration and say voluntarily I have disclosed. The officer can catch you both under the Black Money Act and also can book you under the Money Laundering Act. Then how will people go and disclose if you don't grant them an immunity? Then this is a fait accompli. You don't want this to happen actually. If it is a design or if it is a draftsman's error, the government is going on issuing circulars and press releases. Don't worry, we will not punish you or prosecute under PMLA. The question is the legality. No, parliamentary legislation doesn't grant you immunity. Press releases grant you immunity. Now there is no confidentiality. So after 30th, somebody can file a petition in a court. Please open up and now reveal all this name. Ramjit Malani judgment says, till such time you have pinned them with an offence or an investigation, you don't have to reveal names. But once you do that, you are entitled to release the names. So he will say, now that these people have accepted, please show the names. Next to say, you have shown the names, then you prosecute them under PMLA. And Constitutional Bench has said in Rattan Belting, this conflict has arisen several times, and finally 5 judges have said, circulars can never create law. If law doesn't give a benefit, circulars cannot give benefit. Circular has no force of law. That's the law. So how can you depend on how can you advise somebody on a press note to say you won't be prosecuted under PMLA, you will go and disclose? That's why it has really fallen down in its expectation of just meeting out 500 or even 2,000 crores, let it be. 1997 VDS scheme achieved 10,000 crores. Imagine the cost of money there and cost of money now. Where are we? And you are talking of undisclosed asset outside the country, 500 billion. No match. This is the basic lacuna in the law. That's one. Now, two, for our understanding way forward. See, this law is connected with money laundering from these perspectives. A, an offence under this law becomes also an offence under the money laundering law. Straight away. The money laundering law says it is actually a surrogate legislation or a secondary legislation. It doesn't have to prove an offence independently. It puts a list of scheduled offences, IPC, wildlife conservation, human trafficking, immoral, etc., etc. Catalog of legislations are there. If somebody is booked there and an offence stands true there, then he also becomes an offender under the money laundering law. Straight. Section 51, so far tax crime has not been held to be a laundering offence under the laundering law. Now from July 2015, there is an incorporation, this act has come into force. It says section 51 offence will be a money laundering. So you can, there are four consequences technically. There's a civil consequences of a tax imposition on the income, on the undisclosed income, on the undisclosed asset. That is civil. There can be a prosecution under the black money law. 2. 3. What is considered to be an undisclosed asset or undisclosed income becomes a proceeds of crime under the money laundering law. The whole thing becomes a proceeds of crime. And there is an adjudication mechanism under the money laundering law which says this proceeds can be attached. And because it is a prosecutable offence, you can also be prosecuted under the money laundering law. So there's a tax liability, there's an attachment of the underlying wealth, then there's a prosecution under this law, and there is also a prosecution under the money laundering law. These are the four typical consequences which may flow. In fact, today morning when we were talking, myself and V. Kumar, I was trying to highlight a very interesting nuance in the law. It says, to ensure there is no double jeopardy on a criminal offence. Now, money laundering law has been defined in such a way, it's not enough if you have proceeds of crime with you. You should actually project it as a tainted consideration. It should appear in reality as a tainted consideration. Now, what does it mean? I was giving an example. Somebody commits an act of theft. It's an offence under the criminal IPC. He comes, digs his own house, buries it. Then he can't be prosecuted for laundering. Because he doesn't commit the second offence of projecting it as a tainted money. Whereas he buys jewelry for his wife, laundered. He converts that, sells it as and realizes cash consideration, laundered. So, in a laundering, Income Tax Act, therefore, that's why they said in Income Tax Act, straight away it says this undisclosed income, undisclosed asset becomes a taxable offence under the law. And therefore, once it becomes a scheduled offence under the money, you project it yourself as something else, then you get caught under the money laundering act. This looks to be the typical scenario. Right. Now, last 5 minutes. Who is going to be chased out of this on the basis of this legislation? That's important. There are 4 judgments of the Supreme Court. Asadi Bachu Andolan, Vodafone, Ramjit Malani, and our Hasan Ali Khan's case. Asadi says DTA should be honored and respected because it's a global agreement. And you should put the best interpretative practices in the world as the basis for interpreting a DD. Don't put your own local interpretation. Align yourself with the international good practices and then interpret the law in such a way. There is nothing wrong in executives issuing circular because it is the executive government which enters into a contract. The Mauritius circular still stands water only that for that reasons. So this is one part. Now, Supreme Court improves Asadi into Vodafone. para 68 says, we are aware of all these structures, money going here and there. But we'll have to shut our eyes. As long as, that's the exact word, this investment turns into wealth in the economy. It produces employment. It produces taxes. Payment results in payment of taxes. It catalogs 6-7 items. It says, if this infusion results in an economic growth, then don't go into the source. It's very difficult to find. On the other hand, if this results in a round tripping, paying kickbacks, paying bribery, etc., then consider this as a shell entity and then deal it in accordance with law. See, today, this corporate structures in India is clearly divided into two. All of us know when you read the papers. One structure is a structure which produces wealth. Another structure is a structure kept only for valuation, exit and money laundering. There is no underlying activity in that structure at all. You create the same way a structure is created and keep on overvaluing it. Somebody is valuing it in a matter of 3 years, their valuation is exceeding the industrial tycoons of 76 decades of investment in India. Their valuation in 3 years is matching them or even surpass them in the next. This is the type of valuations people give for exit. So this is simply empty. This is exactly what Supreme Court says. Deal with them, you deal with them carefully. Because these are to be structures, need to be suspected. Fine. Now the third judgment is Jethmalani's judgment, which is still under consideration because SIT has been appointed only under the judgment. Now, this judgment says, I'm not saying, it says, India looks to be a soft state because of the unholy nexus between the lawmaker, lawkeeper, and the lawbreaker. When all the three collide together, it's not good for the state. It says, it records, it talks about politicians, it talks about bureaucratic corruption, it talks about mining mafias, it talks about everything, and says these people actually contribute to the ill-gotten wealth of the country. Recorded facts. Now the fourth judgment is Hassan. Hassan Ali Khan is a shock for any human conscience in India. They go and seize dynamic records worth 68,000 crores involving bank accounts in foreign countries. 68,000 crores seized. No action taken. Now Jethmalani's case is being heard. Then they bring this to the notice of the court. The man is arrested. Fourth day, he is released on bail. Supreme Court interferes, cancels the bail. He goes back to the jail, stays for 2 months. No statement is recorded. When a writ is moved in the Bombay High Court, it says he is a burden to the jail. What are you doing with this man? For 2 months he is sitting there waiting for people to record statement. Nobody is recording any statement from him. He is a clear burden. So throw him out of the jail and he is granted bail. 68,000 crores of documents. So please see the picture, big picture. That's important. The big picture is, see, the compulsion, as he was saying, a corporate entity will have a balance sheet of both income side and expenditure side. It will have an income properly accounted and an expenditure properly accounted. But in an illegitimate business, you can't have a balance sheet of income and expenditure. You can't. But you still run the business. You still have to fund elections. You still have to throw money to win. So what sort of a balance sheet you will prepare? So the point is, this law is going to hunt whose head? They are clearly not going to pursue, Hassan Ali is a typical example, they are clearly not going to pursue transactions involving political and bureaucratic corruption. It will be out of this legislation. So what is left out is only the corporate structure. So officers can simply issue notices. It says there is no time limit for reopening assessment under back money law. Okay? Maybe Supreme Court will finally read it as 16 years, Please show me. So he will come and confront saying, no, these are all P-note transactions, GDR transactions, where do you show? No, I am not going to the investor. I am asking the investor, please show. That's good enough. And it becomes an offense under the BMA Act, and it becomes an offense under the Laundering Act. If you don't give who the, and the onus is on you to prove that who the beneficial owner is. That's what this law says. So, they are ultimately going to hit corporate heads. This legislation will be misused, and it is definitely, when people have cried hoarse to stop GAR from getting implemented, this is more draconic and worse than GAR. You should understand the implication. See, can you stop working with Mauritius? You can't stop. You can't stop. Can you stop election funding the way it's happening? You can't stop. Can you decontrol liquor from the government? You can't stop. Can you destabilize? See, they said, SIT said, P-note is a matter of concern in its second report. Therefore, we must investigate P-note. Stock market tumbled in the next week. See the control they have. You must understand, it's all organized. If they want, they can pull down. If they want, they can pull down. And immediately the FM makes an announcement, hey, we saw the SIT report, we are going to examine what we should do next. Gives a statement, stock market improves. So it's dynamic, extremely interlinked and dynamic. So the lawmaker, lawkeeper and lawmaker is working in collusion. And he will be out of the realms of law. Cause is an example. So this legislation is completely anti-investment. And we are talking of improving ourselves with 100 billion for US. And yesterday we saw the news clipping, Japan is going to contribute this much, South Korea is going to contribute this much, China is going to contribute this much, Dubai is going to contribute this much. And if you are going to tell them, how would you advise? Sir, if it's P-note, GDR, no problem for the investor. But the investing company, we have to show all these details to give an opinion. What sort of an investment he will try to do? He will wobble. When GAR was to be implemented, just take the statistics. It wobbled. And that's why a prudent parcel shows that we defer it. So, trade should take it up seriously because this is completely an anti-investment legislation. It's my personal view. It's a pleasure to have talked to each one of you, and especially in the presence of my senior. I beseech your